The record. While we were off, we did some discussion about our timing. We'll begin the cross-examination with Mr. Shafson from DRA, followed by Mr. Lewis from Joint Parties, if we get that far before lunch. Mr. Warden, would you please stand and raise your right hand? Do you swear or affirm that the testimony you are about to give is true and correct to the best of your knowledge and belief?
Yes.
All right, thank you. Would you please be seated? State and spell your name for the record. Provide a business address.
My name is Russell G. Worden. The address is 2244 Walnut Grove Avenue, Rosemead, California, 91770. And my last name is spelled W-O-R-D-E-N.
Okay, Mr. Weissman.
Thank you, Your Honor. Good morning, Mr. Worden.
Good morning.
And thank you for your patience. I would like to have you look at a series of documents that have been marked for identification as exhibits, and I'll identify the documents and page numbers. Starting with SCE 4,
Okay.
Roman numeral 1 through 4, which is pages 1 through 17, line 1.
Yes.
Next, SCE 7.
Yes.
Roman numeral 1A and B, pages 1 through 2, line 4.
Yes.
In the same exhibit, Roman numeral 1D, page 4, line 3 through page 5, line 24.
Yes.
And Roman numeral 2 on page 8.
Yes.
In exhibit SCE 8, Roman numeral 1 through 2A1, which is pages 1 through 2, line 12.
Yes.
Roman numeral 3, which is page 24, lines 1 through 5.
Yes.
In SCE 9, Roman numeral 1, 2A1 through 2A3, which is pages 1 through 5, line 8.
Yes.
Roman numeral 2B, which is page 6, line 5 through line 14.
Yes.
Roman numeral 2D, page 9, line 6 through 23.
Yes.
Roman numeral 4, parts D, E, F, part 5, and part 6, which is page 19, line 10 through page 27.
Yes.
And Exhibit 11.
Yes.
With respect to all these exhibits that we have just identified, was this testimony prepared by you or under your supervision?
Yes.
Is it true and correct to the best of your knowledge and belief?
Yes.
And do you adopt it as your testimony?
Yes.
Okay, I'd also like you to pull out, please, Exhibit SCE 10.
I have it.
Please turn to page 1.
I'm there.
There was some testimony and questioning with regards to the manner in which Edison accounted for the base O&M expense that's indicated by the green bars on this page. Do you recall that testimony?
Yes, I do.
And did you have an occasion to look into that accounting procedure a little bit further last night?
Yes. As Mr. Perez indicated, the practice at Songs is to charge O&M expenses as they're incurred first to base O&M. After the recorded balances equal the budgeted balances, at that point an analysis begins to identify incremental expenses with additional precision by checking the orders. Once reviewing those orders, a step is taken to allocate them either to incremental inspection and repair or to the refueling outage. And visually, those charges would begin to be allocated after filling the green bar to either the yellow or the gray bar.
Okay, let me stop you there. This process, this methodology of filling the base O&M bucket first, is this something that was made up just for these expenses, or is this something that existed before?
It was not done specifically for this exhibit. It is the customary practice at Songs for both budgeting purposes and for identifying the routine refueling outage expenses or any other major initiative.
Okay. Now, based on the research you did last night, can Edison identify costs that have been classified in Exhibit 10 as base O&M that are attributable to incremental inspection and repair activities?
Yes.
Would it be possible to create a new exhibit that delineates those costs?
Yes, we believe that we can accomplish it within about 2 weeks, and we think it would be helpful to examine the recorded base expense that is strictly attributable to base O&M activities.
So the pregnant pause here is, do we want to do that? Is that right?
We are offering to submit a late filed exhibit along the lines the witness has just described.
Okay, so let me be clear. So you would, what would come out would be a list of charges, accounting charges that were formerly in base O&M by month, that you would then identify that these particular charges were comparable to and related to incremental steam generator replacement or RFO activities.
It would be the first item, Your Honor, that we could identify as being attributable to incremental inspection and repair.
And would that pick up other kinds of charges that are allocated to incremental steam generator expenses already? Or would they be different sorts of charges?
They would be different. Under the customary practice, looking at the bar chart, they would have remained in the green.
No, I mean, actually, as a one-by-one, I understand they're different, but I'm talking about the type of expenses.
They would be attributable to the incremental work that emerged as a result of the outage.
Okay. That sounds like it could be a useful document. I'd like to hear from the parties.
Your Honor, yes, thank you, Your Honor. We believe it might be a useful document. We'd like to see that document. We'd like the opportunity to prepare rebuttal testimony about that document, should we deem that appropriate. Normally I would say we need to be able to cross the witness on that document. But I would like to offer that an alternative to that might be that at some point after the testimony, after we get this document, that Edison make Mr. Warden or whoever else is sponsoring this document available for a deposition here at the Commission. We could ask the sponsoring witness at that point questions about the document, should we need to, and then use that deposition transcript in lieu of cross-examination.
Okay, that's an option. Mr. Friedman, you had your hand up.
Yes, Your Honor. We think that this exhibit would be helpful. And I guess my request related to it would be if we have additional questions, if there's a way to do some quick turnaround discovery.
By data request?
By data request, if there's something along those lines we could do, that would probably suffice from our perspective.
Okay. Anyone else want to weigh in on this? Mr. Giesman?
Your Honor, I would ask if this accounting will be able to identify costs attributable to the long-term repair and replacement activities that Mr. Palmisano was unable to identify yesterday when he said that he was not an accountant.
Okay, fair question. Mr. Warden, we've had testimony that Edison didn't book these costs differently. It didn't distinguish in its accounting which costs related to the outage that were addressing long-term plan activity for 3 versus shorter-term restart plan for number 2. Is the exhibit that you're offering to prepare make any inroads in that kind of segregation?
I don't know yet.
And I would join in Mr. Shapson's and Mr. Friedman's request for discovery and or deposition, depending on how the answer to Mr. Warden's speculation turns out.
Okay. Anyone else wish to weigh in on this? Ms. Benskis?
I agree with these 3, and I think deposition would make more sense. I just think it would be more efficient than data requests and responses.
Ms. Sullivan?
I have a little bit of a procedural question. What is the status of the record between the completion of these hearings and then the next 1B for the replacement power?
The second,
I guess I'm trying to determine
okay.
sort of.
All right, so we're going to address this at the end, but
Okay.
just sort of broadly speaking, the record is open until we close it for this section, which would have been all one phase, but for various reasons, the replacement power piece
Right.
has been moved. So our expectation is that there will be a decision that follows these hearings, that there will be, if there's a late exhibit, we wouldn't close the record until whatever schedule we'd set up to
Okay.
respond to that exhibit. Going forward, the record in this investigation will aggregate, so there will not be a need to reintroduce anything that was put into the record here. You can simply refer to it. As it relates to the refueling, Judge Dudney's going to give more detail about that. That's, at this point, I believe the scope is it's narrow onto the methodology. I'm sorry, not refueling, replacement power is what you asked, right? And he's going to elaborate, but essentially it's a narrow focus, and it may not require a decision if there's no order at that point that no rate recovery might not be dealt with till phase 3. It might simply determine the appropriate methodology to determine how much replacement power is a result of the outage. So for purposes of what we're doing here, there will be a decision this summer.
But the record will remain open if this exhibit offers accepted.
If we decide that we want this exhibit, which I think we do, I think the judges do, and I think it would be useful given what we now know about how the accounting came forward. So we'll decide by the end of the day how we'll approach protecting the rights of the parties to test that information. I'm not sure that there's going to be a lot at issue. It's giving a list of expenses that were recorded and simply identifying where they go differently than where they've been previously identified.
Could I be heard on that, Your Honor, please?
I'm coming back to you. I was responding to Ms. Sullivan.
Sorry.
So does that answer your concerns
Yes.
about whether this is going to stay open and give you an opportunity to respond? Yes. Yes, we will close out this portion. Replacement power will be a separate thing, and then Phase 2 will kick off.
We would agree with the other parties as well.
Okay. Briefly? Yeah.
For clarification.
Take them.
I heard you say that there's going to be a decision following these hearings, and I was not clear does that mean that?
Okay, I'm not going to address that.
No, I'm just asking because in the summer, what I was going to suggest was that whatever spills over, whatever needs to be determined from this could be part of the hearings in August, but it sounds like there's going to be a decision prior to the August decision?
I don't know when it's coming out, but Ms. George, you can leave the administration of the proceeding to us. We'll decide when we are going to issue the decisions and so forth, and I'm not going to get into that now. What we're talking about now is whether we're going to accept a late filed exhibit from Edison and under what circumstances. Mr. Weissman?
Thank you, Your Honor. My suggestion would be we take it one step at a time. So let's serve a late filed exhibit. If parties have questions about it, I would suggest the first step would be a conference call to see if we can answer their questions. If they needed something more formal, I think the second step is data requests, so we can put something into the record. I would hope we do not need to go to the step of depositions, but I guess we could address that at the time if it were necessary.
Yes, okay. All right, we will take that under submission. I think it's clear that we want the exhibit, and I think that Judge Dudney and I will have a discussion about how to structure the instructions on testing that exhibit. Do you have anything to add beyond what I've just said?
Yes, I have a question.
Oh, okay.
What's your name? Sabrina, that's it. Okay. So this has to go with the substance of this offered exhibit. A couple days ago, I had asked for a oral ruling on SCE analyzing and breaking out which of the 130 million costs would be categorized as Unit 2 return to service versus Unit 3 extended shutdown. I was told by Mr. Perez that that SCE could not do that they booked the costs for the Unit 2 return to service in conjunction with the Unit 3, and they couldn't break that out. Your Honor then suggested that SCE and I meet and confer on that. They offered something that is not satisfactory to me or my client, so I was hoping that we could reconsider that. And the reason why I'm bringing it up now is because they're offering this exhibit, and what I would ask is that they go ahead and break out those those categories of costs.
Right, but what you're asking is something that is a far more extensive task, because there's
That's correct.
testimony that says this hasn't been segregated, which means somebody's got to look at thousands of invoices. That's different than going through and looking at a list of costs, which are identified by unit, and figuring out whether some of these base costs need to be moved. That's a different issue than what you're asking, and I think
That is correct.
so I'm not going to grant that request.
Okay.
You can make of it what you will.
Yeah, I mean, I'll just, I'll have my argument then as far as burden of proof.
That's right. Mr. Shapson, let's wrap it up and get to...
Thank you, Your Honor. I need to respond to something that Mr. Weissman said.
Okay.
DRA is not interested in taking this one step at a time. They want to offer an exhibit. We want to be able to respond to that exhibit. We want to be able to do discovery that we deem appropriate on that exhibit. And if we're not allowed to cross and do discovery and respond to the exhibit, then we object to it.
All right, duly noted. Thank you,
Thank
Mr.
you.
Shapson. All right. So, with that, under submission, let's move to Mr. Warden's cross-examination. Mr. Shapson?
Thank you, Your Honor. Good morning, Mr. Warden.
Good morning.
My name is Mitchell Shapson. I represent the Division of Ratepayer Advocates, along with Laura Tedisco in this proceeding. Let's start with page 14 of Exhibit 4.
I'm there.
Have there been any payments subsequent to the $45.4 million indicated on line 8?
No, there have not. But I do want to assure you, Mr. Shapson, that if Southern California Edison receives, is permitted recovery of its costs, and then receives either additional payments from, or any payments from MHI or from the Neal insurance policy, that our policy would be to convey that to the ratepayer. We're not interested in collecting twice, but only being made whole for the outage.
Do you know if Mitsubishi is disputing any portion of the warranty payment?
My understanding is they're disputing all of it, including the 45.4.
Do you know if Edison and Mitsubishi have entered into any arbitration activities?
Not yet. Let me clarify. I'm sorry, Mr. Shapson. I understand that they have not yet. Not that I don't understand yet.
Well, there's a lot of things we understand and don't understand. As far as you know, they have not done so.
Correct.
Thank you. Let's turn the page to 16, please.
I'm there.
Could you look over the last paragraph, specifically line 21, 22?
Yes, I see it.
Have the future reductions that you say will occur in the first half of 2013 occurred?
Objection, Your Honor. Scope.
It's a foundation to another question that does go to the costs in 2012.
All right, I'll allow it.
They are underway, Mr. Shapson. It's a more lengthy process because the last wave affected employees who are represented employees, and under their collective bargaining agreements, there are a series of bumping rights, and that is underway now. Last I checked, it was expected to be concluded sometime this summer.
Do you know what the current estimated savings are?
They're the same as what is in the testimony, I think. Yeah, savings.
So do you know what the difference...
Can we wait a moment?
sorry.
Because I'm not sure that that's the correct answer.
I don't have the ultimate savings expected based on the actual reductions through 2013.
Do you know what the current full-time equivalent is at Songs?
Your Honor, I'm going to reiterate my scope objection.
Right, at what point in time, Mr. Shafson, we're talking
Now as compared, so we can compare it to 12.
And how does that impact 2012?
It helps us understand what was being done in 2012, what if they've reduced by a certain amount, the savings that they've realized from that might have been realized earlier. So it helps us pin a number on what might have been realized in 2012.
Well, I don't think you have to go to the 2014 current state of things, because there's absolutely no evidence to show why personnel ebbed and flowed in the interim.
I'm trying to go to 2013.
Even so, I guess I'm not seeing the connection. Maybe you could try again. I mean, it might be relevant if it's less than what they expected, it might be relevant if it was less than what they estimated, and why in 2012.
I understand, Your Honor. Thank you. I'm going to move on.
Okay.
Mr. Warden, I'd like to ask you a few questions about Edison 7.
I have it.
Thank you. On what do you base your belief that Edison acted prudently with regard to the cause of the outage?
Objection, Your Honor. Scope.
Sustained.
Thank you, Your Honor. Then I would like to move to strike line 3 and 4, the part of the sentence on page 2 that reads, Edison believes that the evidence will demonstrate that it acted prudently. I believe when you read it in context, that's referring to the cause of the outage.
Sorry, where are you?
This is page 2.
Page again?
Page 2, the sentence that starts on line 3.
I don't.
I am moving to strike the words, Edison believes that the evidence will demonstrate that it acted prudently.
I don't object to striking that.
Granted.
Okay, thank you. Ask you about Exhibit 9, please.
I'm there.
I'm not.
You need a moment off the record, Mr. Shafson?
I'm ready.
Okay, let's go.
Let's turn to page 3, please.
I'm there.
So I'm feeling very confused by what you wrote in the first and second full paragraphs. Can you take a moment and look those over?
Let's go off the record for just a moment.
Thank you. So in the second paragraph, it starts in this way. And as I read it, the in this way refers to the example that is in the paragraph before that, the third sentence, I believe. Is that a correct reading?
I'm not sure I understand the question, but maybe I could.
Well, I can ask it again if you don't understand it.
Well, why don't you let him rephrase the question?
The beginning of the second full paragraph says, in this way. What does that refer to?
The previous paragraph.
Okay, and the previous paragraph has an example in it. So are you referring to that example?
What I'm referring to is that under cost of service rate making, the utilities have an opportunity to earn a regulated rate of return over the life of an asset. The fact that rates are set that provide the utility such an opportunity comes with it also the obligation to dedicate it to utility service. Said another way, you can earn an authorized rate of return, but the asset will be devoted to original cost rate making, which was established with the Hope decision in 1944 and is really the basis of cost of service rate making.
Why don't we stop there and see if you consider that?
So is there another way to say that? I'm sorry, Your Honor, I didn't mean to interrupt you.
No, I'm just getting it back to you.
So are the IOUs and the ratepayers sharing a risk in that construct that you've described?
I think there's an obligation. The utility accepts a regulated rate of return. The Commission sets rates according to the principles of cost of service, which includes that utilities are entitled to recover their reasonably incurred expenses.
And is risk part of that construct?
You accept a risk that if you don't manage your expenses, or if you were to act imprudently, then you might not earn your authorized return.
Did you understand, or what is your understanding with regard to the risk sharing in procurement of energy as opposed to a plant that is rate-based?
I'm not that acquainted with the purchase power or energy and capacity side of our business, so I can't really go and offer an opinion there.
Thank you. So if we could read, I'm sorry, strike that. Along the lines of the prior motion that I made, I'd like to also move to strike the first sentence on the top of page 5, the portion that reads, Edison believes that it operated songs unit 2 and 3 prudently.
I don't oppose that.
You're taking out just up through prudently, or that whole sentence?
Well, they can reserve the right. It's fine with me.
Reserve your right. Okay.
I don't think it's going to go anywhere, but...
All right, we'll strike, hearing no objection, we'll strike the first half of that sentence through and, or I guess we leave SCE in, reserves. So it reads, SCE reserves the right to make this showing in later phases. We'll strike the intervening words. Does that conform with your request?
From believes to prudently.
Yes. No,
Yes.
and.
That's deferred anyway, just so you know, but, so are you asking
Right.
for it to be stricken?
He wants to strike, yeah.
That's fine with me.
Okay.
Let's look on page 6, please.
I'm there.
The last sentence of your testimony.
Line 19.
No, I'm sorry. I believe that your testimony ends.
Oh, I'm sorry.
It's your testimony is section B, as I understand it. Is that correct, counsel?
Yes, it is.
Thank you. And the sentence starts, SCE provides.
Yes.
Okay. I asked Mr. Perez about this the other day. It says scheduled pending the restart of Unit 2. Do you believe that the restart is a sure thing?
At what point in time?
At any point in time.
Well, I'll object to the extent it goes beyond 2012.
Sustained.
Okay, then let's take that sentence out as well. So it talks about the restart.
No, I don't think that's appropriate to take the sentence out.
Could
can ask him.
you reframe that to an argument besides no?
Pardon me, Your Honor. I object to the request that this sentence be stricken.
On the grounds?
That it is relevant, that the understanding and belief with respect to the restart of Unit 2 in 2012 is relevant to Phase 1.
And I tend to agree unless you've got something sterling to persuade me otherwise.
The possibility, shall we say, level of probability of the restart is certainly something that all of the parties have been talking about in 2012. And
Yes.
it goes, and their Edison's certainty with regard to that restart affected how they spent money in 2012.
Well, that's in my view, that mischaracterizes the testimony. I heard no witness say that in 2012 they had certainty the restart would occur. They had scheduled dates. They let those dates slip. What I guess I see this as relevant because there was ample testimony that as they gathered information, they formulated a restart plan, which parties are free to argue they think was not reasonable for whatever reason. But the issue is, what did they do, and was it reasonable, and what costs were incurred as a consequence? There are costs in 2012 that were incurred as a consequence of their understanding that a restart plan was feasible and put forward. You may disagree with that.
Let me rephrase then. Let me rephrase. Well,
I think it's relevant.
no, I would never disagree with you, Your Honor, but let me rephrase the question.
Can I write that down, Mr. Jefferson?
Absolutely. Do you know what Edison's level of certainty in 2012 they had with regard to the potential restart of Unit 2?
It evolved over time. On February 1st of 2012, the day after the steam leak was discovered, nobody thought the outage would last 15 or 16 months. And there were incremental decisions and incremental timelines as more knowledge was gained. But it seems to me the reasonableness consideration must take into account that the company did not have perfect knowledge about the ensuing 16 months on February 1st of 2012.
Thank you. I'd like to move to strike that portion of the answer that was non-responsive to the question.
Which portion was responsive that you'd like to keep?
The last 90%. I understand that the witnesses testified that they had knowledge that was dynamic during 2012 about the possibility of a restart.
And you object to that part of the testimony?
No, I understand that, but the rest of it was not responsive.
Okay. Sustained. Let's strike following. I'm not sure exactly where that... Let's go off the record for a moment. Tom, are you able... exactly what was said?
evolved over time. On February 1st of 2012, the day after the steam leak was discovered, nobody thought the outage would last 15 or 16 months. And there were incremental decisions and incremental timelines as more knowledge was gained.
Is that where you were?
I think
You
we're
think
good.
that, okay, so, and then what follows? I'm sorry. We're trying to figure out where to draw the line.
But it seems to me the reasonableness consideration must take into account that the company did not have perfect knowledge about the ensuing 16 months on February 1st of 2012.
All right, so your motion is to strike everything after, including but it seems to me.
Yes.
And you can have your 2 cents on it, but I'm going to
Thanks.
grant that motion. Okay, thank you, and thank you, sir. All right, continue.
In 2012, did Edison ever consider the possibility that the restart plan would not be granted or actually be effectuated?
Objection, Your Honor, lacks foundation.
Overruled.
I don't know. Edison's a big company.
Perhaps you could be a bit more responsive, Mr. Warden, to the extent, did you have personal knowledge of any discussions during 2012 in which options surrounding restart were discussed and the possibility that the NRC might not approve it was considered?
I don't recall that topic in 2012. I don't recall hearing those discussions. So I don't recall any of those.
Thank you. Half a second, Connor.
Off the record.
I'm sorry, Your Honor. Can I just reserve a couple minutes at the end, and then I'll be done? I have a question. I just can't seem to find it right now.
Okay.
Thank you.
All right, let's go back on the record. Mr. Shafson is going to defer to another party, although he's reserving a couple of questions. So, Mr. Friedman, Mr. Lewis, right? Was going to be second? Did you have agreement?
I thought Mr. Lewis was going to second.
Yes, Mr. Lewis.